Welcome everybody to the latest edition of Vidhi's Book Adda. Today we have the pleasure, we have joining us Mr. Rohan J. Alva, and thank you very much, sir, for joining us.
Welcome.
Mr. Alva is a counsel at the Supreme Court of India, and he earned his LLM at the Harvard Law School, where he was a Tata scholar and a Harvard Law School scholar with a specialization in constitutional law. Finally, he has written the book that we are going to be discussing today, Liberty After Freedom. It's a book that studies a very specific and very significant provision of the Constitution of India, one of our most cherished fundamental rights, Article 21. The phrasing of this is relevant, and I think it's good to say the phrasing out loud and hear it once more, because as the discussion goes forward, we'll realize that it is in the words exactly that the whole story is unfolding. The provision says that no person shall be, why won't you go for...
deprived of their life or personal liberty, except according to procedure established by law.
Yes. The question is of a deprivation of life and liberty. Life, liberty, things that we really hold dear. And the condition that is provided in the provision, on the basis of which the government is permitted to take away life and liberty, deprive it, reduce it in any nature, is merely that there must be procedure established by law. Now, if you think about this in terms of common parlance, what does this word mean? What could it possibly mean? Think of an example of how it happens. Somebody decides that, a government decides that they want to pass a law providing for death penalty for certain actions, taking away their life entirely. And it says that all that needs to be done is that a particular person needs to feel, according to without any restriction on their discretion, if a person feels that somebody deserves it and they can write down their reasons, this sounds like a procedure, that's enough. It sounds like even the most minimal procedure, as long as it is laid down in law, is enough to take away the most precious things that humans hold dear, life. And yet it sounds so jarring to think of rights in this manner. If all it takes to take away your life is that a legislature should pass a law with minimal requirements, then is it even a right against the legislature? Is it merely a right against the executive branch of government? And yet this is the exact phrasing which you will find in the Constitution. And it seems as if you could say that we were shortchanged during the drafting of the Constitution of our actual rights, the rights that we would deserve when it comes to the protection of our life and liberty. What could it have been? Why wasn't it as it was? And what can we expect from the way in which constitutional law and Article 21's law evolves in future in trying to bring it back to the level of protection that we would like it to be? These are the subject matters, as I understand, that Mr. Alva has thoroughly studied in his book. And at this point, I'd like to ask you, Mr. Alva, that when you came up with this idea of studying this particular subject, Article 21, and you came at it with the approach that you did, which is to say a focus on the drafting process at the time that the Constituent Assembly was drafting it, what did you have in mind? How did you, what was the thought process when you first felt that this is a subject matter that deserves greater attention? Yeah. What were the stakes at hand? And why do you feel that this particular subject deserves to be heard by more of us?
First of all, thank you for that warm introduction, and thank you all for being here. And it feels great to be here at Vidhi. I've been following it for years and how well it's been doing. And I'm glad I got this chance. So this book actually I was thinking about it for many years, because there's a certain story that, I would say all law students are brought up on how this important right was actually framed by the Constituent Assembly. And the story that I was told, and the story which everyone was told, is basically there were international actors involved, there was a Japanese constitution involved, there were switches involved in terms of those who first supported due process and those who opposed it, and there was a lot of intense debate over the final form that Article 21 must take. And ultimately it boils down to two main stories. One of them is that B.N. Rao, who was the Constituent Assembly's constitutional advisor, went to the United States and he met these great judges, Justice Felix Frankfurter and Judge Learned Hand, who told him that please do away with due process. Don't have anything of that kind in your constitution, because the American experience has been very controversial. In some, due process has been the basis to invalidate a large number of socio-economic laws. So you will follow the same path that America went down, so just do away with due process. That seems to be one story. The other story is that the Constituent Assembly looked to the Japanese constitution, the 1946 constitution, and there was a particular article which was similar to what we find today in Article 21. And what the Constituent Assembly thought, and this is what we were told, is they looked to the Japanese constitution and they said it's been framed under American guidance. Clearly the due process guarantee is absent from that constitution. There must be some reason for it. We'll just copy the Japanese constitution and incorporate it into our constitution. Now, as I write in the book, and as Lalit wrote a very generous review of it, and he also covered it, I dispute these two stories, and that's really the idea which was the basis for this book, that it's not a simple story that can be told to us that this is how the most important provision actually came to life. You've seen what has happened in the past few years, ever since the right to privacy, decriminalization of homosexuality, before that and since, how the fulcrum and the basis was Article 21. Now, if this is such an important right, there must surely be something in its history which either tells us how it was created or which can help us to understand how to give it proper shape. So that's basically where I started, and I tried to put together in this book this story in a way to understand how we came to the text of Article 21, which is why I focus on the period from 1946 to 1950. And how did we choose those words, life, personal liberty, except according to procedure established by law, person, how did those words fit into Article 21? And far from being a simple decision that the Constituent Assembly undertook, it was a battle which started in December of 1946 and it ended on the 26th of January 1950. So it was nearly half a decade long battle which was waged over what the right to life and personal liberty must mean.
And this is actually important when we are trying to figure out what the stakes are. As you mentioned, our current understanding today, if you look at how Article 21 is operationalized, how it is put into action, you will find that the range of things that it covers and the standard of protection that our courts provide for those things, for the interests, as you mentioned, questions which are currently called by the moniker decisional privacy, questions related to LGBT rights, questions related to abortion, questions related to other intimate decisions that individuals take, other questions which have to do with detention and liberty in terms of physical movement that aren't covered in other provisions, a range of other questions about how life can be made dignified and not just be an animal existence. All of these are so different from how Article 21 looks like when you read its wording, that one would imagine that there is a question of concern. If words can change so easily, if the meaning of words and their effects can change so easily, what are the problems that are involved?
Yeah.
This is I'm trying to.
So the best way to understand this is not to take it as a linear story, is to take it in phases. So the first phase in terms of its historical evolution will be from 46 to 47. And interestingly, the person who first told the Constituent Assembly that you need something like due process was Dr. B.R. Ambedkar, when he replied to Nehru's.
Just, Alva, if I may, it would be good if we could just explain what the import of due process is.
Yes.
What does it mean?
I'll just come to that. And he said, and he was replying to Nehru's objectives resolution, and he said, look, in your objectives resolution, you've given this entire path that the Assembly must adopt. But in your statement on fundamental rights, there's an important right that must be present. And that is, no person's life or liberty is to be taken away except according to due process of law. Now he left it at that. He made this statement. In fact, he was called upon by Dr. Rajendra Prasad to address the Assembly. He was not prepared, so he spoke extempore because he assumed there were about 20 people to speak before him, and he just left it at that. This intervention had an impact between January and April of 1947. And between January and April of 1947, the advisory committee, which was headed by Sardar Patel, which created in turn a fundamental rights subcommittee, really went into due process in the most exhaustive manner possible. And there were basically several concerns before them. The first was, how do we ensure that unwarranted detention is prevented in independent India? That was the primary concern. The second concern was, how do we ensure that the constitution has a right which can become the basis for recognizing other rights, what we today know as unenumerated rights, which are part of the constitution. Privacy, etc. are not mentioned in the text, but you can still locate them to Article 21. So which right gives us the best basis to make that argument? The third was, should due process protection apply to property rights? Because the idea was that we must dismantle this entire zamindari system. So should due process protection apply to property rights or not? The fourth concern was, how do we relate due process to judicial review? Because it's a big problem if citizens come to the court and second guess legislative wisdom and get laws overturned. So how do we sort of link it and give a coherent framework to it? And the decision that they ultimately took was that life and personal liberty deserve the highest form of protection. There is no second guessing that. And the highest form of protection that can be given is due process protection. And the decision incidentally was taken that property rights will be kept out of due process because zamindari system and dismantling it will become difficult, if not impossible. So the Indian innovation was, unlike the American Constitution, that due process protection will apply only to life and liberty. And this was sanctified in the decision of the Constituent Assembly on the 30th of April 1947. If you ever have a chance, you should read those debates which lasted in the last week of April of 1947. It's one of the most fascinating debates on due process. And ultimately, a due process guarantee was voted upon unanimously and universally by the Constituent Assembly. So these were some of the main concerns. And as I show in the book, that is the zenith, that's the pinnacle of due process, and after that it just keeps sliding down all the way until 1950, when by a series of coincidences and a series of events, due process is first watered down, and then finally it is removed entirely from the Constitution. So these were some of the main concerns which sort of were uppermost in the mind of the Assembly members when they were deciding what is the shape that must be given to fundamental rights.
It's relevant here to just put into your view the rigor with which the Constituent Assembly went about drafting the Constitution.
Yeah.
There were multiple rounds. The entire Assembly was there, then an advisory committee was there, and the committee had subcommittees that had to deal with fundamental rights. There was a first round, certain calls were taken by the Constituent Assembly, then the advisory committee and the fundamental rights subcommittee and the drafting committee came in and added in new views that the Constituent Assembly itself had not taken at the outset. And finally, once again, this was presented to the Constituent Assembly so that they sign off on it. And that's what we found at the end. So this entire process is the focus largely of Mr. Alva's book.
So that's the first phase. The second phase, as you were saying, is how does the watering down begin? Now here is a very interesting theory that's been put forth. And the theory is that B.N. Rao is the man responsible for convincing the Constituent Assembly that due process must be done away with. Now I find, and I found this from the sources, that something the opposite happened. And what happened was that from America when he had gone, and this relates to your question, he sent an air letter, which at that time was something which was a princely thing to send apparently. And then he sent a letter to the Assembly and said, look, I have consulted with all the greatest jurists in America, and I have been told that this due process guarantee will be problematic. So what did he propose? He proposed something like what we know as Article 31C of the Constitution. He said that under no circumstances should a law that is made in effect to give effect or directive principle, that law should never be struck down. Not on due process, not on any fundamental
Court
right.
should not be looking at
Court
that.
should not touch a law which has a social welfare or a public purpose aim. So his solution was, you retain the due process guarantee, but create a stipulation in the Constitution that a law made for a giving effect or directive principle is immune from judicial review. And that's basically the second phase which due process undergoes, where due process exists to protect life and personal liberty, as you said, against detention, against other forms of assaults on personal liberty. But due process can never be used to invalidate a law to give effect to a directive principle of state policy. Now this was the second phase. Now the third phase is where the about phase happens in the drafting committee. Now why is this about phase important? three members of the drafting committee had an important role to play in getting due process rights recognized in 1947 itself. Dr. Ambedkar, Aladi Krishna Swamy Iyer, and K.M. Munshi. Now, in August of 1947, after independence, the Constituent Assembly decided, and this is just purely in terms of structure, that what we have been doing so far is we take a fundamental right, we have a debate, and then we have a vote on it. It's getting too complicated. Let's create a drafting committee which will give us a working document, and then we'll debate, have an article-wise deliberation. It'll be easier, it'll be quicker. Apparently, the drafting committee rejected B.N. Rao's advice. And they said, we are not going to have any provision in the constitution where laws are immune from judicial review. You can have conditions, but you cannot immunize laws from judicial review. So as such, it appeared in this third phase that B.N. Rao's advice was rejected. Due process rights would be a part of the constitution, and laws meant to give effect to directive principles of state policy would be subject matter of judicial review for violating fundamental rights. This is what it appeared somewhere in late 1947, early 1948. Now, when Dr. Ambedkar rose to address the assembly on the 4th of November 1948 and present the draft constitution, due process was absent. There was no mention of it. And instead came Article 21, what we know as Article 21 today, that no person will be deprived of life and personal liberty except according to procedure established by law. And literally, when you read the debates, you can see that the debates just exploded when it came to numerous members in the assembly being incredulous at the fact that the drafting committee had abandoned due process protection for life and liberty and brought something weakly worded in their opinion like Article 21.
Procedure established by
Procedure established by law.
I think it's worthwhile to take a moment here just to get everybody on the same page about exactly what this alternative is, the idea of due process, because it will really bring to mind what was possible and was let go of. This idea of due process, if you have to compare it with the words procedure established by law, as we were mentioning that example earlier, if you just see the words procedure established by law, it sounds like if there is a law and it has the procedure, however minimal and negligible that procedure is, that's it, that's enough. You can take away life and liberty if there is just some procedure. What due process does, and here the word due plays a good amount of lifts quite a bit of weight. It suggests that there is something that the court has to examine and see whether or not it is appropriate, whether it fits, whether it is significant enough, the reasons and justifications that the government provides to take away life and liberty. It shouldn't just be laid down in law, but it should meet some standard of sufficiency. And this is where the entire question comes up. How much responsibility should courts be given in trying to figure out when governments should be allowed to take away life and liberty? That's the basic differentiation that you have to keep in mind. That according to one, legislature can create a procedure. According to the other alternative, the court actually has to find out whether the reasons given by the law, by the legislature, are enough to take away something as significant as this. And here I want to just change tack a little bit and ask you how you feel when you were preparing and researching for this book. Did you feel any sense of doubts about the way in which this perspective of a historian, a legal historian almost, who has to look at documents, communications, and has to try and decipher what people had in mind when they drafted it in the way they did? Did you feel there were certain difficulties that a person faces, and is this perhaps a sense of it's not possible to do it, it's kind of futile to try and find out their motives? Or would you feel like in other provisions of the constitution it is in fact possible to find out what the motivations of the drafters were? And if you'll allow me a second one, why are the motivations and why are the personal convictions of the people who drafted, the individuals who drafted the constitution, why is it important to want to know what they were?
Yeah, so that's a very important question, because anyone who has had a passing occasion to see the history of Article 21 will be told that it was a very simple decision-making process that ultimately life and liberty was chosen. But something important happened in August 47, which relates directly. Aladi Krishna Swamy Iyer, who was a long-standing Advocate General of Madras, and then he was an important member of the Assembly, He said, look, we are creating a drafting committee, but what is its mandate? The mandate of the drafting committee is to reduce past decisions as articles in the Constitution. If we find some problem, if we find an error, if we find something unconscionable in this past decision, then we can change it, we can differ with it, but this past decision has to be reduced as an article in the Constitution. And he said this, and this became relevant from the perspective of due process, because as I just said, on the 30th of April 1947, there was a unanimous approval for the due process guarantee. So it appeared, and Aladi said this so as to calm the mood, that nothing revolutionary will happen. We voted on a lot of aspects. They will find a mention in the Constitution. Now the drafting committee rejected this advice, and they went against it. And when it came to the assembly, Aladi Krishnaswamy Iyer became the greatest opponent of due process rights, although he was the greatest proponent.
Yes.
He is the man, I would say, single-handedly responsible for ensuring that the assembly knew what due process rights were. And on the 6th of December 1948, he became its greatest opponent. And he became an opponent because he said, now we as the drafting committee speak for the assembly, and we have decided that there is no question of a constitution containing a due process. If you have a better argument, he actually challenged K.M. Munshi, if you have a better argument, you give it to me. I may change my mind, but as far as I am concerned, due process is going to remain out of the Constitution. Now, why did this become important is that both K.M. Munshi from the and Aladi Krishnaswamy Iyer from the drafting committee now were on the opposite sides of the debate. Munshi spoke in support and Aladi Krishnaswamy Iyer spoke against. But both of them had the same justification, and that was the democratic justification. So according to Munshi, K.M. Munshi, democracy was in fact ennobled with a due process guarantee because you would create this pathway where a citizen can challenge laws. The exact opposite was the stand of Iyer, who said you will harm democracy if you constantly allow people to go to courts and review violations which affect their life and personal liberty. But anyway, this carried on right up till 1947. They really couldn't convince the drafting committee to have a rethink about it. And ultimately, Article 21 in its final form came into the Constitution. Now, what struck me was that there's a very faithful adherence between the 1950s and the 1970s to treat whatever the drafting committee said as the gospel truth. So if the drafting committee said we don't like due process, that's it. There's no question of right to life and liberty becoming a strong right. And that's what I investigate in the book. And the conclusion that I draw is that if we are to ascribe any sort of intent to this body of people who compose the drafting committee, there have to be some preconditions in place. We can't just ascribe intent in a vacuum. So what are some of the preconditions? Some of the preconditions are universal acceptance. Another precondition may be unanimity in terms of the language of the right itself, not only about the principle, but the language of the right itself. A third principle may be that this universal decision is reflective of the general mood of the constituent body. A fourth may be that the people themselves accept the decision of the drafting committee, so therefore the drafting committee, truly speaking, is reflecting the will of the people. And what I conclude is that none of these preconditions existed. The drafting committee went against an express decision of the assembly. There was division within the drafting committee itself. There was no universal acceptance about it. The assembly was deeply unhappy with it, and there's proof about why they were unhappy in two ways. Firstly, because of the debates itself, and secondly, of what happened after 1948 when new articles were introduced to give effect to some modicum of due process rights, which formally were called a compromise and an apology for abandoning due process in 1948.
The detention-related
provisions. It actually came as an apology. So much so they said that this is how we are apologizing for abandoning due process, bringing in Article 22. And the fourth was the people were unhappy with it because there was widespread discontent which sort of was reflected in the speeches of the members in the assembly who kept telling the drafting committee, you have a relook at it and rethink your position about abandoning due process rights. So therefore, what I conclude is that there is no question of ascribing a particular original intent to Article 21 if this is the method by which we will decide to ascribe some sort of original meaning or original intent of Article 21 so as to permanently keep away due process rights.
Now, I'd like to challenge this version of how we should be viewing it to some extent, to see where it can lead us. As we were discussing these two alternatives of due process and procedure established by law, under one, courts are not given any role in trying to find out whether a law passed by the legislature is adequate in some way. In another, they are given role, but the extent to which the courts are guided in trying to figure out what it means is just due process. It just says something has to be due. If you are asked tomorrow to find out whether or not a procedure created by, let's say, your employer is appropriate or due or reasonable, if that's all that's there, would you feel like you are being given any guidance about how to find out what is due, how to find out what is appropriate? These are the kinds of concerns that come from the other end of the spectrum. Even if we can all agree the procedure established by law is an extremely weak and inadequate protection for our life and liberty, it would still be a question about whether due process is too loose a wording. And here the question might come up that perhaps the Constituent Assembly did not have the risk appetite. They could not conceive of giving over so much power, and this may have been a legitimate view that many of them had held and so voted in favor of. They didn't like procedure established by law, sure, but they didn't like due process even more.
Yeah.
And what middle path was possible was not available until future interpretation by courts.
Yeah. So that's one way to look at it, but there are two important points to consider. The first is that, and this is what all comparative law scholars will always look at it, is that Indians feared an American-style jurisprudence emerging in India where social welfare laws would be struck down. Now, the reason why that fear was unfounded is found in many speeches, including of Sardar Patel. And he said that unlike the American Constitution, there are three important supporting features which make justable fundamental rights important. First is that we are actually enumerating it, so it's in the text. Secondly, they are enforceable in terms of using it to strike down laws. And the third is the right to move the Supreme Court itself, which is being made a fundamental right. Now, if this is the supporting structure that the Constitution itself is creating, then whether to strike down something or to challenge something as violating due process, or for challenging something by saying that it is unreasonable, is really to say the same thing basically. So what is unreasonable would almost always mean that it is without due process, and once we sort of accept reasonableness as the guiding principle in fundamental rights, we are really speaking the language of due process. That was the first. The second, and which was the very important criticism, was that the drafting committee tried to sidestep this entire controversy by saying that, look, we've copied Article 31 of the Japanese Constitution. It has something similar, and that Japanese Constitution is an inspiration to us. So pat came the reply, please look at the Japanese Constitution. And please look at the Charter of Civil Liberty Rights which follow Article 31. If you're truly replicating the Japanese Constitution, why did you not also replicate the Charter of Due Process Rights? And this is most important. Specific types of due process rights which are part of the entire panoply of natural justice were mentioned as specific fundamental rights in the Japanese Constitution. So the criticism was, if you're copying Article 31, then please copy everything that follows after it, because only then does without procedure established by law make sense, because you're told what cannot be taken away by law.
And it's worth mentioning that many of these rights that the Constituent Assembly had before them in the same Japanese Constitution where they picked up this procedure established by law from, many of these rights have since been brought in by the Supreme Court, but some are still not recognized.
Some are not, but that's a question of incorporating fundamental rights.
Yes, I mean to say that they had the opportunity to bring it in, and we still don't have it because
they had the opportunity, and this was the main question, that when you say something can't be taken away by law, you must also then qualify what should never be taken away by law. So the obverse has to be present in the Constitution. Only then possibly could Article 21 make some sense. But just putting in a fundamental right that anything can be taken away except according to procedure established by law, not defining certain inalienable rights, was actually contrary to your own reasons and your arguments which justified Article 21, which once again attacked the very idea that the vision or the ideas of this drafting committee will constantly control the future development of fundamental rights.
On this future development, as courts have to look at it, this I think is, I think the impetus behind your choosing this subject is because when courts look back at these words,
Right.
and they have this focus on their intention, one of the doctrines or one of the principles that courts apply is that if a particular phrasing was considered by the drafters and then rejected after consideration in favor of something else, then any morsel, any fragment of that previous thing that was rejected also gets thrown out the window with that rejection. There's no consideration of it at all. And I think this is why the question comes up when courts have to say these things, that of course if they changed it, their intention was to have nothing of due process. No 1 out of 10 fraction of due process anymore in our constitution if they rejected it. If that is the way they're going to speak about it, then it's worth questioning that way of courts, the way that courts work like this. It's worth questioning whether their imputation of intentions to the drafters can be problematic. And here,
Yeah.
I found it extremely striking how the inconsistencies that were drawn out, that you drew out in your book, especially one that struck me, while the drafting committee was still considering due process as its chosen language, it had the question of life, liberty and property, language that it drew from United States. But they dropped property, saying that we should not have courts interfering with how property is being taken away. We shouldn't have them reviewing when zamindars' properties are taken away and given to farmers. This should not be something courts should be looking into. The government should be given full scope to do this. And yet in the final draft, property turns up in Article 19 with the ability of courts to be able to reflect, to review it, to look into whether these things, whether the taking away of property is being done on reasonable grounds. So the very thing that they were afraid of, that the Constituent Assembly was afraid of, that zamindari abolition would be reviewed by courts, was the very thing that once more turned up in Article 19 anyway. So it's the intention itself seems confused.
No, there were a lot of reversals. There were a lot of flip-flops, a lot of reversals. Property was one. So as you just correctly said, property, the assembly was told, do not give due process protection to property rights, only to life and liberty. And in 1950, life and liberty was got no due process protection, but property rights got it in 19 and 31. There was another very interesting development that took place, and in the post-1970 era, which will also tell us how history continues to control our present and our future. Now, the way it exerts control is very interesting. B.N. Rao had told the assembly that there are two models available to you in terms of framing a right. One is, on the one hand, is the American Constitution with due process, life, liberty, property. And on the other hand is the Irish Constitution, which says that you may take away any person's personal liberty save in accordance with law. And he said this phrase and B.N. Rao actually wrote a very strong memo, and he said a phrase like save in accordance with law, except according to procedure established by law, etc. are all, frankly, they are just as decorative pieces in the Constitution. They afford no protection. So do not, and he said this I think 3 to 4 times, do not follow the Irish Constitution. But don't follow the American Constitution, have some sort of middle path. And what was the middle path that Rao said? Rao said that use due process protection for life and liberty, but make sure that social welfare is not harmed by due process rights. And as I show in the book, after 1970 and Maneka Gandhi, India had what I called a counter-Lochner era, where rather than striking down social welfare laws, not only was Article 21 used to uphold social welfare laws, but surprisingly directive principles were read into due process rights in order to recognize a range of socio-economic rights. And the reason this is important is because they were directly heeding the lesson and the warning that B.N. Rao had given, that a fundamental right must allow for progress, but it must balance it with social welfare and public goal. And that is what we have seen has happened in India in the 1970s and importantly in the 1980s.
Right. On this thread, it's worthwhile to take it forward a little bit, right. Because one of the positions that you bring forward or that emerges from your book is that it's what has happened since the Constitution came into force, what has happened, the history of the evolution of Article 21 and how courts have interpreted it, how they have expanded what it means and how they have raised better protections for it over time. That has been a good development, precisely because courts have been able to again consider this possibility of due process, a higher standard that the government has to meet. They've been able to consider it anew despite these linguistic barriers that Article 21 had in place. And yet, if you come now to our present position in 2019, to now 2022, there has been the emergence of a standard called proportionality under the judgment, the K.S. Puttaswamy judgment in 2019, which seems to 2018, I believe, which seems to use these keywords, due process, and yet takes its actual content of the test not from America but from Europe.
Right.
So would you feel that perhaps the debate on due process particularly can be a little misleading, in the sense that there are other alternatives once more that are beyond that debate?
Right.
Or would you say that due process and proportionality have a lot in common?
No, I think they are not opposed, but in fact they both have to go together, because proportionality will never tell you what is the right that you need. Proportionality may perhaps tell you what can be achieved and what is the best basis for achieving it. But to understand what is the guarantee in the first place, what is the minimum core of that right which must exist, what is the nature of that right, you need something like due process, or you need some other indication that which tells you that this is the particular fundamental right that we are talking about.
What is the thing you're protecting?
Yeah, so first we need to understand what exactly you're protecting, and only then can we go to questions and discussions of whether the measure itself is proportionate, justified, reasonable. But I think proportionality in isolation will not help us to understand what is really the nature or the nomenclature or the substance of the right that we will apply proportionality analysis to.
Would you say that in recent debates, would you say that the story that you have to tell, would you say that it's worth people looking at it, especially when they're considering recent debates in America? The Roe versus Wade judgment on abortion has a very direct nexus with this question of due process. To what standard must you hold the government when they take away certain kinds of things? But what things? The decision to be able to give birth to a child or choose not to give birth to a child, that kind of decision, the choice of that right, how do you get to it? Should courts be allowed to protect it, or should they be letting it go? That, we have marital rape proceedings on the constitutionality of marital rape happening in India, on gay marriage happening in India. Would you feel that people should realize the significance of what's at play when these contemporary debates are happening?
And this is very important for the future of rights. America's problem is that they suffer from two important drawbacks. The first is judicial review is not explicitly mentioned the way it is in our constitution. It was actually rested in Marbury versus Madison by Chief Justice Marshall. So the controversy is this idea that courts will question legislative wisdom, will question administrative actions, is alien to the constitution, is in fact is a strong belief. The second is that because there is this preliminary objection to judicial review itself, it relates directly to recognition of due process rights, and especially unenumerated rights, which are rights not textually present in the constitution but which can be brought within the framework of liberty or life. Now, our experience and our architecture and the constitution's architecture is different from that. So it is, to some extent, we can justify judicial review in the first place because it is explicitly given in the constitution. And because we can justify judicial review, we can also justify the fact that certain rights are recognized by the constitution which can be implemented or can be recognized, or alternatively you can question state action affecting those rights through the medium of judicial review. So I think the structure of the constitution makes a big difference in the way we analyze and implement due process rights. And related to that, as you just said, was a very important development. Now again, why does history inform the future? On the 1st of December 1948, the Constituent Assembly debated Article 19, then draft Article 13. So freedom of speech, expression, freedom of association, etc. And Pandit Thakurdas Bhargava launched a trenchant attack on abandoning reasonableness protection for freedom of speech and expression. So if you all see the debates, apart from freedom and speech, the other civil liberty rights could be taken away subject to reasonable restrictions. Now this word reasonable was there in the original constitution, and it was put in order to ensure that civil liberty rights have to be protected in a very strong manner. So therefore rigorous review of state action that affects civil liberty rights. So Bhargava's argument was that if you have put reasonableness in Article 19, why don't you put the same for life and liberty in Article 21? You have accepted the principle of due process protection, which incidentally came in for the freedom of speech by the First Amendment, which is why today we have due process protection for the freedom of speech. And that became important because if you couldn't locate it within the text of Article 21, what happened was that you started reading it with Article 19. So post 1970, R.C. Cooper, etc., you started reading Article 19 and Article 21 together. And the end result of that was that the due process standard review, which was very much part of 19, was now brought into Article 21 and for life and liberty, which is how today we are able to create a justified framework to at least assert that there are certain rights which are worth protecting, even though not mentioned in the Constitution.
And if you think about it, it's quite naive to believe that in 1950, all the liberties worth higher protection would be possible to know at that level and list out in Article 19. What does 19 list? The freedom to speech and expression, association, it at that time had property, and 3 or 4 other issues. But there are other freedoms that individuals have.
Right.
And it's strange to believe that only these deserve higher protection,
right,
and none other could rise even above the low level of protection 21 provided. Right. There has to be some differentiation between the kinds of liberties we have.
And that is why there were these several moves which were made. So one was to read 19 with 21. The other was to have a new reading of 21 itself, apart from reading 19 and 21 together. The third, as I just said, was to look at our history and understand that the abandonment of due process happened in the most unceremonious manner. There's a history of due process being recognized for life and liberty, which justifies it. So there are several ways in which we can sort of pin it to Article 21. But ultimately the fact is that the principle of due process, even though it might not be present in those very words, was very much part of the original constitution, and it was very much part of how the assembly had thought life and liberty should be preserved.
At this stage, I think it's appropriate that we open it up to the rest of the audience. So if there are any questions that you have on the basis of the discussion you have heard, any questions about the subject matter, especially if you have followed proceedings, you have followed the developments in Indian law regarding these particular significant rights, please feel free to raise your hand, and we'll take them up now. Would you have any? Yep. Yeah, we'll just take a mic on.
No, that's fine.
No?
That's fine. I mean, I'm sure we can be all.
Yeah.
For some recording.
I guess
Anyway, whatever.
there is a mic. There is a mic coming.
So thanks very much, Rohan. I think it's first of all great work. As in, I think it's a story that needed to be told because there's a lot of myths floating around, and I think you've done a great job in dispelling these myths. I had 2 questions. The first is not so much in relation to procedure established by law vis-a-vis due process, but in relation to the other part, which is the right to life and personal liberty. And there, given the fact that these rights have been hugely expanded by the Supreme Court over a course of the last 70 odd years, perhaps right at the beginning with some justification, and then I think there's a time after Bhagwati's court when it tends to go a little bit off kilter. And there are many things now that are recognized as part of this right to life, and so whether it be reasonable things such as the right to emergency health care, or perhaps like in that Ramlila Maidan case, the right to sleep as being part of a fundamental right. So I was wondering first whether you had any thoughts about whether there would be a reasonable extent to which unenumerated rights can extend. Because I think it brings in fundamentally the question, if it goes too far, that what does it mean to have a right in the first place? So that's number one. Number two is in relation to what you said vis-a-vis the question on proportionality. I agree with you entirely that proportionality obviously doesn't tell you what the right is, and I think this is a mistake that we often make, that all our discussions are around the restriction itself without first asserting what the right is. But perhaps there is now a court-sanctioned justification for that, because if we look at the principle of arbitrariness in Article 14, which now extends to legislation as well if it is manifestly arbitrary, then actually what the courts are saying is that if a legislation is arbitrary, then it can be struck down on the basis of Article 14. Now, that in some sense means that I don't have to say that there is a right in the first place. I can just say that this legislation is arbitrary. For whatever reasons it is arbitrary, it could very well be arbitrary. So do you think that the content of the right itself has ceased to be of as much relevance as perhaps it ought to be?
So,
Yeah, I mean, just to give this a little context, the manifest arbitrariness test, it has just used these four terms. Caprice, it also uses disproportionality, it uses something about determining principle, inadequacy of determining principle, very broad terms, but none of which actually talk about the content of the right. So if these are fusing proportionality, due process and arbitrariness, and courts have given that indication, yes, that is a...
I think the first question about life and liberty, as far as 21 was concerned, life, everyone knew, had a particular and specified meaning. It basically meant, can you deprive a person of their life according to some procedure? Liberty became that flexible, boundless word in which you could fill up a large number of rights. Now, there are some rights which automatically we would believe are part of Article 21 and some we would not. For example, the Supreme Court in the early 80s issued a blanket injunction. It was just an order. If you read the judgment, it's a short order. And they banned public executions across India because public executions apparently were happening in some states. That is an example of a substantive analysis of a particular regulation. Now, the court had before it a situation where neither that right to sort of non-public execution, none of that was part of the Constitution. But what this idea of due process did is that it allowed the court to recognize that regardless of other considerations, there are certain substantive interests which have to be protected unconditionally. Now, I agree that the spectrum is wide, so there are certain rights which we may disagree are not to be part of it, etc. But the fundamental idea is that here what we are trying to figure out is whether we have a platform by way of which we can try and understand and incorporate certain rights in the Constitution without at least getting into the aspect that certain rights are really inessential or not part of 21. Whether we have that platform in the first place. Now, whether it can be stretched to cover a large number of rights is always going to be a case-by-case basis, because it's impossible to say with certainty that certain rights are or are not part of 21. Secondly, proportionality is extremely essential because it gives us a structured way to analyze restrictions that are imposed on a fundamental right. So if you have two extremes where you have judicial review which will not engage and your judicial review which will use generalized words to invalidate regulations without us understanding, proportionality gives us a middle path. But again, I feel that proportionality sometimes can make it exceptionally difficult. I'll give you, like as Orgo said, emergency healthcare. We may agree that emergency healthcare is part of the minimum core of a socio-economic right. It has to be given. Now, what happens if emergency healthcare means providing an expensive medicine on a regular basis when you are not entitled to it by government schemes? This question has come up time and again in the Delhi High Court. Lots of children who are unable to access life-saving medicines, for them the minimum core itself is access to that medicine. So I think the language of the right really depends on the circumstances, and like you can only craft proportionality analysis by, I think, first tracing and establishing really the framework of the right and what is the urgent need in question before deciding what are the means and the ends that should be applied.
Yes, and it makes sense that even if there is such a thing as evening or dusk, that doesn't mean that we can't differentiate night and day and night. And the idea that there must be something in life and liberty that deserves higher protection is something we should have common agreement upon. Are there any further questions?
Am I audible?
Yeah.
Yeah. You talked a bit about unenumerated rights. So I think there is another category. Unenumerated rights are basically something that we interpreted.
Right.
We found a justification under Article 21. But then there is another category which is directive policy, directive principles. Since the expansion of Article 21 is so wide, we know that in the recent judgments, the courts have interpreted DPSP as a part of Article 21, certain rights. For instance, legal aid, primary education. So, do you think this kind of an interpretation, taking DPSP and then putting it, and interpreting it within the part of Article 21, do you think this somehow disbalances the basic structure of the Constitution? Because there is a reason why they have been put as a part of directive principles.
Yes.
So that's
So you are right that in terms of the neat division between fundamental rights and directive principles, it's very clear that directive principles are unenforceable, can't be implemented, whereas fundamental rights can be. And once again, going back again to the history, the reason is that when due process and this idea that liberty can be interpreted broadly became a part of our jurisprudence, there was clearly this idea, the direction in which it must go. Should it go in the same direction like the United States, where it becomes a sort of sword where every single social welfare law is invalidated? Or should the interpretation of Article 21 be used progressively, what is now widely called progressive interpretation? So some scholars, for example, put a counterfactual question. Assume there is no directive principle. Would you still recognize it in Article 21? The answer probably will be 9 out of 10 you would. So therefore, technically speaking, the presence of directive principles may not make much of a difference to the implementation of rights. But the problem arises because the structure of directive principles doesn't allow it. So if you look at directive principles, they're structured in three ways. You have broad declaratory principles, some conditions of living, conditions of work. Then you come to specifics, minimum wages, and then you come to certain abstract principles which you can never bring into 21. For example, separation of powers between the state and the judiciary. Now that's not something that you can locate in Article 21. So there is that systemic problem that every single directive principle can't be incorporated into Article 21. But there are certain principles which, as the courts have put it, are also part of directive principles which can be located in 21. But then the question comes, how do you implement it? How do you recognize it? And that's where proportionality analysis becomes important.
Any further questions? I had a further question that I had in mind. You've covered this particular provision in considerable detail, Article 21. But I wanted you to give us a little bit of an idea about when you compare Article 21's text and how that text played out after the Constitution came into force with the way in which the stories of other provisions. I'd have Article 14 particularly in mind. In Article 14, they did choose the language that was directly taken from the American Constitution. This is the opposite of Article 21.
Yeah, but 14, just if I can, 14 has the most astounding story.
Yeah.
It was always part of Article 21.
Yeah, it earlier
Just before the Constitution had to be framed, the drafting committee picked out equality and made it Article 14. That's really the story of Article 14.
Yeah.
There was no deliberation. Today it's one of the most powerful rights, but that's how it was actually created. It was just picked out of 21 and made a new Article 14, and then life and personal liberty.
Yeah. But this story of separating the two of them has also resulted not just from the fact that they were separated and kept in different provisions, but also the language and the borrowing that happened. They didn't borrow the same thing from America in Article 21, And so courts felt that that means nothing about American law is going to come in to India.
Yeah.
On the other hand, in Article 14, they chose the exact language from the American Constitution. So courts felt that if they are going to choose the American Constitution's language, we have to follow it doggedly, assiduously, and with more real...
And that happened because from 47 up till 1950, the 14th Amendment was what was being replicated. So the 14th Amendment has an equal protection clause and a due process clause.
Yeah.
So that's why it was together, and only in the end it was separated.
Yes, but would you feel like this is indicative of how Indian courts are unwilling to apply their mind systematically to come up with new ways of interpreting it, especially early on? They would not apply themselves systematically to come up with new ways of interpreting these provisions, and would stick quite mechanically to this idea of intention, and keeping that on one hand, and keeping on the other hand the way in which they interpret it now. Would you feel like the way they interpret it now is desirable?
So there is a lot of work that is available on how original intention itself flip-flopped in the 1950s. For example, the Supreme Court in A.K. Gopalan downwards right up to 78 said the original intention of Article 21 is to keep due process rights out. And they relied on the drafting committee's working, saying the drafting committee was an agent of the assembly, and we will therefore follow what the drafting committee says. Now in property rights, the opposite happened. They went against original intent, and they struck down laws on relating to land reform, even though the original intent was that these particular articles are sufficient for the purpose of acquiring property and having land redistribution. So within 19 and 21, in the 1950s itself, there was a disavowal of original intent when it came to property rights, but an adherence to it when it came to life and liberty. So even it was not consistently applied across the board for all fundamental rights.
But would you say that they were critically analyzing the provisions? Were they being too mechanical at the time? Or was that only the experience that made it apparent to them?
Again, the problem was that the word reasonable was a part of Article 19, and reasonable brought in due process review. So no matter how you worded the law and the text, ultimately you would subject it to due process review, and therefore the law, it was possible to strike down a law even if you put all the necessary safeguards in the Constitution. That's basically what happened. And ultimately by the 1970s, and this is just before the Maneka Gandhi era begins, 1950 you had due process protection for property rights, not for life and liberty. And by the 44th Amendment, you neither had due process protection for property rights, and life and liberty anyway was ignored because it was made into Article 300A. So that's basically the lot of flip-flops, and by the 70s and by the 80s they realized that this property rights had to be taken out of the purview of due process, and the attention had to shift to life and liberty.
A last question: is there? How would you see the outlook from here? And this is on the basis of what you've been talking about, how history is informing our present nature. Do you feel like history is being abandoned to some extent, and that is with good reason, perhaps? Or would you feel that some shadows of history continue to haunt us?
No, history, this entire history, as I just said, from 46 to 50, tells us 2-3 important things. But the most important thing that it tells us is no matter how good the justification for a restriction on liberty will be, especially on liberty will be, it has to be rigorously reviewed to see whether it meets certain particular standards. There are no two ways about it. So, and as I also say, if there is no original intent to Article 21, then conversely, if we look at what happened between 46 and 47, then you can actually ascribe due process as the original intent to Article 2. It's possible to make that argument, as I've said, but the lesson that you draw from it is that the words themselves sometimes can be manipulated to give low-level protection, and the same words can become the basis for granting the highest level of protection for any action which affects liberty or personal liberty.
That, I think, puts the debate into considerable context. It's the responsibility that our constitutional functionaries have that is most important to keep under scrutiny and hold to account. And I think that's perhaps a lesson to take away from this, that the words are, they may be as they are, mistakes may have been made in the past, but the people responsible today to implement them are the ones that we must look to see whether they are doing it right. And with this, I think we'll close this
Thank you
discussion.
so much. Thank you.
Thank you so much,
The
Mr.
pleasure.
Alva.
Thank you all for being here.
Yes.
Thank you. Thanks again.
It's nice to be able to clap.
Sir, would you